Hi, good evening. Welcome back to again that new wage code and the power of its definitions under section 2 has been illustrated by government. Let me give it, the foundational and critical. Sometimes it's seen as a legal jargon. You scroll past to get the juicy part head first into section 2 of the code on wages, which is nothing less than dictionary for the entire law. It unpacks the definition that shape and define the codes. So let us first define the importance of the section 2. You have to admit that these definitions are most intimidated and their prospects are very high. Everyone feel dry when they pour their thoughts into the notes, and you'll be convinced that these definitions are not just footnote, they are the keystone of the entire structure. If you don't understand exactly who count as an employee or a worker or what truly legally counts as wages, you will be flying blind when it comes to understanding your rights and your obligations. So let me also further move on to understand the analogies of these definitions. In any legal framework, when you take whether it is labor law, whether it is company law, whether it is financial law, the rule of the game is basically illustrated as a board. They tell you that who are the players into this relation. So let me first go on the first two players is employee versus worker, where the boundaries lies what constitute an establishment and who the referees. The appropriate government skip them, and you risk two things: first, missing out on right you thought you had, and second, discovering obligation, penalties, liabilities that you never realized applied to you. Our goal of this talk would be to translate the legalese into practical, actionable terms. We will clarify who set the rules and who is covered, and how the courts aim to finally close the notorious loopholes in the wages calculation that employers have exploited for decades. A lot of employers, they were of opinion that minimum wages is nothing but a combination of wages, basic wages, and allowances. Let's start with the operational basics, where work happens and who is in charge. So, establishment and appropriate government, the first talk in respect of the clause M, that will really stratify the situation. So this definition remarkably broad and deliberately explained in too far. It defines simply as any place where industry, business, trade or occupation is carried on. Think factories, corporates, tech offices, corner shops, and even the government offices. It's trying to be comprehensive. It's an everything from a massive manufacturing plant in an SEZ to the smallest neighborhood grocery store to a fintech startup operating from a co-working space. So the modern definitions of business, if I add in now fintech and co-working space, basically, then it will be more understandable to a lot of business. So the context and the missing piece is that the framer of the code understood that modern work is decentralized, where the contracting, subcontracting, and even the part-time working, even the working from home has been started in a very large volume and very high scale with a very cheap cost. These broad definitions really made it quite protectional for the employees, for the worker, and not confined to the traditional office building. The business activity is happening. If people are being paid for wages, it counts as an establishment. Crucial however, limit what is not explicitly defined. The fully decentralized gig economy touch on later, but for traditional employment, the net is wide. There are no special carve out for the government work. If people work there, it counts. So the clause M, appropriate government, if I talk about that covered in the clause M, this is not a theoretical point. This definition is intensely practical because it determines who makes the rules. Where do you file complaints or raise disputes? The code split jurisdictions between the central government and the state government. Now, central governments cover sector deemed to be of national, strategic, or interstate importance. This include railway, mines or oil field, banking and insurance companies, major port and airports, telecommunication, any establishment operating across more than one state. These are area where uniformity of law and labor standard across the country is essential. If you work for the State Bank of India or the Indian Railway, you actually follow central government rule and approach central authorities for redressal. Now, in the state jurisdiction, everything else is in the state jurisdictions. That is, vast majority of establishments in India fall under the state jurisdiction. This include local grocery store, retail shop, a standalone manufacturing unit. You see that restaurant and hotels, a state level educational institutional. The difference in jurisdiction can be significant. The minimum wages set by the central government might differ from those set by your local state government. The takeaway here is simple. If you are filing a complaint or checking your rights, knowing your appropriate government is the first step. So this become a purely expert job now. Ordinary people, ordinary team is not able to handle these areas because all support would be, I think, from the expertise support which are digitally to be incorporated. Everyone reviewed their app and who makes the rules. Now let's define the who is actually covered by these rules. Now let me take the another definitions of employee versus worker. Now I used to think employee and worker were interchangeable terms, but under this code they are decided not. This distinction is essential to grasp as it determines which specific protections you are entitled to. Broad sweep of employee clause K. It is anyone working for wages in an establishment. It's a wide sweep that covers the spectrum. Anyone, any person. So any person, when I say, it's a wide sweep. It could be man, woman, old man, young man, whatever. Any transgender, any third gender, any handicap. So it's anywhere working for. So it is a wide sweep that covers the spectrum of the broad workforce. Unskilled labor, especially labor's classification is made unskilled labor, highly skilled software technicians, senior manager, officers. It's the default status. However, the code explicitly excludes specific categories such as apprentice, specific under the Apprentice Act, and armed force personnel. Essentially, if you are working for a salary or fee, you are the another category of employment is the protected group, clause Z, worker. On the other hand, it is crucial subset of employees entitled to a special historic labor protection, particularly those related to the industrial dispute, the right to unionize, and a specific safety provision. This typically include those unskilled work, skilled or technical work, operational or clerical work, even some supervisory work. The management line, the threshold line is drawn at the management if your duties are purely managerial or administrative. You fall outside the definition of worker even if you are an employee. The code introduced a key financial threshold for supervisory role. If you supervise the line and earn above a specific monthly limit, which is subject to the periodic adjustments, but often cited around 15,000 to 18,000 mark in related legislation, serving as an indicator for who is considered lower level supervision, you might be deemed a part of the management rather than a protected worker. Now, scenario A, if I take it more lucidly and intensely, the employee and worker, a highly skilled welding technicians who operate the machines, they are an employee by definition, and they are also a worker because their role is operational and technical. They get the full suite of protections. But another category, if I define, and scenario B, if I create the employee only, a general manager or a chief financial officers, they are clearly employee working for a wages, but their role is purely managerial and administrative. So they are not the worker. So under this code, let us now further define what is important and why those important and why it is matter. The difference is not trivial. It affects who can raise an industrial dispute, who is covered by the Industrial Dispute Act, and who can access a specific government conciliation machinery. If you are a worker, you have a significant additional layer of legal armor that a managerial employee does not. The code is essentially ensuring that most vulnerable and non managerial staff retain the most robust protections. Now, line between the employer and the worker gets further complicated when a third party become involved. We call the contractor. So, closing the exploitation loophole, the contractor and contract labor has been taken on very different. Again, they are defined any person. So, any person, again, the definition is very broad and wide, but they are working on hire implicitly or explicitly with the principal employer, with the client. Historically, labor supplied through a third party has been one of the most significant area of wage exploitation. The code attempt to address that directly. So, contractor under clause F simply a person or entity that supply labor for the fee. This is a staffing firm, the BPO, the third party security agency. These are the basically agent and agency partners who will supply the contract labor through their services. So this is the workforce, that is the workforce supplied by the contractor. Their vulnerability for the decades, company used contract labor as a loophole, basically using them to the main and core area of work of the company. But now that has been thwarted out. By using contractor, they could avoid giving these workers the same benefit, job security and wage as their permanent employee. That was the earlier case, though the contract worker were often performing the same task side by side. Now the path to the parity, big shift. The parity has been brought in and disparity has been allowed completely. The new code signals a significant shift. It establishes a path to parity and attempt to define what a genuine contract worker relationship is, rather than a disguised permanent one. The essence of the code intention is this: if a contractor threat you exactly like a permanent employee with equivalent benefit, appropriate leaves, and periodic raises, you are not classified as vulnerable contract labor under this act. So the equality test, if you try to do, then what does this equality test look like a practice? It focuses on substances of the employment relationship, not just the. It is written on the parity in benefit. It is written on the parity in benefits basically are the contract worker receiving health insurance, provident fund contribution, social security benefit at a level comparable to the main establishment employees. Parity in leave, do they have access to the same sick leave entitlement? Yes, they have. Parity in wages, are their wages, base wages, commensurate with the work performed, preventing the contractor from simply undercutting the market? Now, let me give some more throughput on the gig worker or gig economy that is in question. This section also critically important when we look at the growing gig economy. Many platform-based workers are technically independent contractor, but they often resemble contract labor in their lack of protection and dependence on the principal employer, the plate. While the code on wages itself is somewhat additional. So the spirit of the contract labor definition is to push back against exploitation. It gives a green light to legitimate a staffing firm, provided they offer their contract worker proper employment style protections and not just bare minimum wages. So the ultimate goal of any wage code is, of course, to define wages. This is where the most of the money games have been played, and where the code on wages clamp down hardest. The money or wages, what in, what outs, approximately in the definition, if I correctly could explain you, and you may receive it in the same manner. So most contentious and of course critical definitions of wages. Clause 2 Subclause Y. It's simply term. It is all remuneration payable to a person for work done. This form the core of the payment. What is included? The core explicit inclusion, the following three components in the definition of wages. These are basic pay, the fundamental salary component, DNS allowance, the cost of living adjustment, then retaining allowances, any payment made to an employee for simply retaining their services during period where they can an off-season employee, off-season retainers. Okay. These three are the indisputable component of a person legal wages. So these are the wages actually. Earlier when we used to say wages, all component of wages are become the wages, means gross wages. That kind of terminology in this new wage code is not there at all. Now, what is in excluded component? However, the definition is equally important for what it explicitly excludes. These are the payment that do not count towards uh, the calculation of legal wages, such as bonuses tied to productivity or profit sharing, the value of housing accommodation, especially HRA, or traveling concession TA, overtime pay, the employer contribution to any pension or provident fund. So, exclusion now no company can weaponize because there is a limit on it, and historically it was the weapon with them that there are a lot of components they used to put into the exclusion, and basic wages and DA to be maintained to their different mindset, and altogether when they add basic wages and allowances, they say that the composite of the basic and allowances would be the minimum wages. But in new wage code that has been thwarted. So historically, employer would weaponize these exclusions. They would creatively structure salary to keep the basic pay component extremely low, sometimes as low as 10% of total pay, and load the rest of these exclusion in other components such as HRA, travel, and bonuses. Why? Because the lower the defined wages, the lower the employer obligations to contribute to the social security, to certain fund benefit of EPF and ESIC medical contribution. That was the mechanism to minimize liability and shortchange employee long-term savings. Now, clamp down under this new wage code is a 50% rule. The Code on Wages clamped down on this practice while not explicitly stated in the document definition. The intention is codified by a rule that limit the amount of the excluded component, especially HRA TA bonuses, to be less than 50% of the employee total remuneration. If the excluded payment exceed 50%, the excess amount must be treated as wages. This is the anti-loophole provision. It ensures that a fairer, more realistic definition of wage is maintained, forcing employer to define at least half of the total compensation as the core wages, upon which all social security contribution must be calculated. This is a massive win for employee financial stability and preventing creative salary structuring that shortchanging them. Now, in conclusion, looking ahead, let me recap and synthesize my talk so far, which I made. We have completed our deep dive into the definition of Section 2, where we try to understand establishment, a place of business, and any appropriate government, center or a state, employee, anyone working for wages, but a worker is a subset of employee with a special statutory protections, specifically excluding purely manager role. Contract labor is given a path to parity, forcing contractor to provide actual employment style benefit to avoid the historical exploitation loophole. And finally, wages are now protected by 50% rule, ensuring that social security contributions are calculated on a realistic and fair base amount. So this is a new evolving landscapes on wages, and as I look ahead, I am keen to see how these definitions held up as the modern world of work continue to evolve. Do they cover delivery riders and platform-based freelancers who are not technically employees or workers? How they will be covered? That completely, understandings yet to be, uh, you know, revealed, and if suppose companies are dealing this type of things, I will come back and again talk to you on that, how their wages to be structured. Will tech company find new workaround to the 50% wage rule? The law is always to a step behind innovation. So this is more on innovation. If you see the new wage code, the practicality would be seen in the another 6 months when these would be transferred on the stage. So now let us be how master the section 2, understanding exactly where one stand, and encourage everyone to review their own payslip. With these definitions in the mind, you might find you qualify for benefit you didn't realize were due, or that your employer need to adjust how they classify you. Uh, on closing note, thank you for joining me on the deep dive Viaco View in their legal episode and channel. I'll see next time when we tackle section 3 and explore ways in detail. Thank you.